I am documenting a protection architecture. On December 19th, 2025, the United States Department of Justice released what it described as the first batch of documents related to Jeffrey Epstein, convicted sex offender, accused sex trafficker, individual who operated for decades within networks of power, finance, and political access before dying in federal custody in 2019. The release came in response to the Epstein Files Transparency Act, legislation passed with near-unanimous bipartisan support, signed into law by President Donald Trump, mandating full disclosure within 30 days. The law contains specific language prohibiting any redaction or withholding based on embarrassment, reputational harm, or political sensitivity, including to any government official, public figure, or foreign dignitary. What I observe in the documents that were released, what becomes visible, not in the content, but in the structure of concealment, is a system where protection is not declared, it is administered. The initial release contained thousands of pages, many entirely redacted. 119 pages of grand jury testimony, material a federal judge had approved for unsealing, presented as solid black rectangles. No text, no context, just the visual confirmation that something existed and that someone decided you would not see it. And other pages showed inconsistent patterns. The same individual redacted in one photograph, visible in another. Faces blacked out in some images, recognizable in duplicates. Victims' names, individuals legally entitled to privacy, exposed in multiple documents, triggering harassment, unsolicited contact, re-traumatization. Meanwhile, other names associated with wealth, institutional position, political leverage, protected with mechanical consistency. This is not a story about what the documents contain. This is a story about who controls the architecture of visibility and what that architecture protects. Asterisk, asterisk, layer 1, the sudden discovery, asterisk, asterisk, on December 24th, 2025, 5 days after the legally mandated deadline, 4 days after the first heavily redacted release, the Department of Justice announced via social media that the U.S. Attorney for the Southern District of New York and the FBI had uncovered over 1 million more documents potentially related to the Jeffrey Epstein case. I document the language uncovered, not classified, not withheld pending review. Uncovered, as though these documents had been lost, as though the most scrutinized federal investigation of the past decade, involving the most high-profile defendant to die in federal custody, under circumstances that triggered congressional hearings, somehow misplaced over 1 million records. The Southern District of New York prosecuted Epstein in 2019. It prosecuted Ghislaine Maxwell in 2021. It has had continuous institutional control over these files for 6 years. The FBI has had investigative access for 14. What I am documenting is not forgetfulness. I am documenting a disclosure structure where the existence of evidence is revealed incrementally only when legal or political pressure makes concealment untenable. The DOJ statement continued. We have lawyers working around the clock to review and make the legally required redactions to protect victims, and we will release the documents as soon as possible. Due to the mass volume of material, this process may take a few more weeks. 200 government lawyers were assigned to the redaction process, according to Deputy Attorney General Todd Blanche, each one making decisions, each one determining what constitutes victim protection versus what constitutes institutional embarrassment, each one exercising judgment about where the line falls between transparency mandated by law and protection extended by discretion. What the Epstein Files Transparency Act explicitly prohibits is redaction for embarrassment or political sensitivity. What the DOJ now claims is that all redactions serve victim protection, but the documents themselves, the ones already released, reveal a different structure. The redaction pattern, I trace the visibility architecture through what was released versus what was concealed. Former President Bill Clinton appears in multiple photographs. In a hot tub, arms behind his head, next to a person whose face is redacted, described by DOJ as a victim, on a plane with another redacted individual, in a pool with Ghislaine Maxwell, Epstein's longtime associate and convicted sex trafficker, at events with celebrities, Michael Jackson, Kevin Spacey, Mick Jagger, whose presence in Epstein's social orbit is now part of the public record. Clinton has never been charged with any crime related to Epstein. His spokesperson issued a statement. There are two types of people here. The first group knew nothing and cut Epstein off before his crimes came to light. The second group continued relationships with him after we're in the first. The statement also demanded full transparency. What the Department of Justice has released so far, and the manner in which it did so, makes one thing clear: someone or something is being protected. We do not know whom, what, or why. What I observe is the structural irony. The individual whose images were most prominently featured in the initial release is now demanding to know what is being withheld. President Donald Trump appears far less frequently in the first batch, with his name referenced in passing. A photograph on Steve Bannon's phone showing Trump with Ghislaine Maxwell. Flight logs from the 1990s documenting travel on Epstein's aircraft. Trips Trump has acknowledged, trips predating Epstein's criminal convictions. But the second release, published December 23rd, after initial criticism of the first batch's heavy focus on Clinton, contained substantially more Trump references. Emails, witness statements, allegations, the DOJ itself labeled untrue and sensationalist claims made against President Trump that were submitted to the FBI right before the 2020 election. The DOJ added, if they had a shred of credibility, they certainly would have been weaponized against President Trump already. What I am documenting here is not whether these claims are true or false. What I am documenting is the selective editorial commentary. The DOJ did not provide similar disclaimers for materials involving other public figures. It did not preemptively label allegations against anyone else as sensationalist. It exercised discretion in a manner that suggests protection through narrative framing, even when releasing the underlying material. The inconsistency as evidence, asterisk, asterisk. The redaction inconsistencies are not errors. They are structural revelations. A photograph appears twice in the released files. In one version, a specific individual's face is blacked out. In the duplicate, the same person is visible. The DOJ initially explained this as an abundance of caution, protecting anyone who might potentially be a victim. But if protection were the governing principle, both versions would be redacted. The fact that one is and one is not reveals discretionary judgment applied inconsistently. A set of images was uploaded to the DOJ's public Epstein Library website. One showed a drawer containing a framed photograph of Trump surrounded by women. Hours later, it was removed. The DOJ claimed concerns about whether the women depicted were victims. Days later, after review, it was restored, determined there is no evidence that any Epstein victims are depicted in the photograph. But what I observe in this sequence is not victim protection. It is the visibility of institutional uncertainty about how far protection extends and to whom. Survivors of Epstein's abuse, individuals represented by attorneys who have spent years fighting for accountability, issued a joint statement. No financial documents were released. Grand jury minutes, though approved by a federal judge for release, were fully blacked out, not the scattered redactions that might be expected to protect victim names, but 119 full pages blacked out. They continued, some of these documents contain the names of more than 24 alleged victims and were posted without redactions. We have received incoming from individuals alleging to be victims, requesting that certain information be removed. What this reveals is inversion. Those legally entitled to protection were exposed. Those whose names carry institutional weight were shielded. The architecture operated in reverse. Bobinone obeys the Assange contrast. I document the accountability asymmetry. Julian Assange published classified US military and diplomatic cables in 2010. Materials documenting war crimes, civilian casualties, systematic abuses within detention facilities. He did not commit the abuses, he did not order the operations, he published evidence of them. For this he faced Espionage Act charges, the first publisher ever prosecuted under that statute, 11 years of detention without trial, 5 in maximum security Belmarsh prison, 7 confined to the Ecuadorian embassy, CIA plots to kidnap or assassinate him, revealed through protected testimony, a plea deal requiring him to admit guilt, to obtain freedom, stripping his ability to file freedom of information requests about his own persecution. The message delivered by this sequence was clear. If you make state criminality visible, the state will make you disappear. Now I observe the Epstein file release structure. 14 years of investigation, multiple prosecutions, convictions obtained, Epstein dead, Maxwell imprisoned, and yet over 1 million documents uncovered only when Congress passes a transparency law with enforcement deadlines. Redactions applied in patterns that protect institutional figures more effectively than victims. Grand jury materials approved for release by federal judges, presented as black rectangles, and the individuals responsible for these decisions, 200 government lawyers, named in aggregate, never individually, operating under guidance from leadership whose names appear in official statements, but whose specific redaction decisions remain opaque. Protected by the architecture of bureaucratic diffusion, where responsibility is distributed so thoroughly that accountability becomes impossible to locate. No one will face Espionage Act charges for withholding these documents past the legal deadline. No one will be prosecuted for redacting materials the law explicitly prohibited from redaction. No one will spend years in detention for protecting powerful figures from embarrassment or reputational harm, the exact standard the law forbids. What I am documenting is a permission structure where visibility of state and elite criminality is punished with total institutional force, while concealment of that same criminality is rewarded with career protection, legal immunity, and structural invisibility. The testimonial void. The grand jury testimony, 119 pages entirely redacted, represents the evidentiary center of this architecture. Grand juries hear witness testimony under oath. They review evidence, and they determine whether probable cause exists to bring charges. In Epstein's case, multiple grand juries convened over multiple jurisdictions. Witnesses testified, records were created, and then those records were sealed. Federal judges authorized their release. The Epstein Files Transparency Act mandated their publication, and the DOJ presented them as solid black pages. Survivors' attorneys noted in their statement, these are not scattered redactions. This is total concealment. What grand jury testimony typically contains: names of witnesses, descriptions of criminal acts, identification of co-conspirators, financial transaction details, communication records, location specifics, timeline documentation, all of it according to the DOJ, too sensitive to release, even with victim names redacted. But the law does not permit withholding based on sensitivity. It permits redaction only for victim protection and classified national security information. Neither standard explains blacking out 119 consecutive pages. What I observe in this void is the shape of what is being protected, not individual reputations. Those are already compromised by association, not operational security. Epstein is dead, Maxwell imprisoned, the criminal network theoretically dismantled. What is being protected is the evidentiary record of who knew what and when, who facilitated access, who received financial benefit, who held institutional positions that enabled rather than interrupted the operation, who made decisions in law enforcement, in prosecution offices, in judicial chambers that allowed the network to continue functioning for decades, despite multiple prior investigations, multiple prior warnings, multiple prior victims coming forward. The grand jury testimony would answer those questions. That is why it remains concealed. It's an architecture of complicity. I return to the core observation. This is not a story about Jeffrey Epstein. Epstein is dead. His criminal operation is documented. His conviction is secured. His co-conspirator is imprisoned. This is a story about the system that protects itself, even when ordered by law to expose itself. The Epstein Files Transparency Act passed with near unanimous support. Republicans and Democrats voted together. Trump signed it. Congress set a deadline. The public demanded accountability. And yet what was delivered was a partial release missing the legally mandated deadline. Over 1 million documents discovered only after that deadline passed. Inconsistent redaction, protecting some figures while exposing others. Victim names leaked while powerful names concealed. Grand jury testimony reduced to black rectangle. No individual accountability for any of these decisions. What I am documenting, what the redaction patterns themselves make visible, is that 14 years after Epstein's crimes became federal investigative priority, the architecture built to conceal those crimes remains operational. It no longer operates through Epstein, it operates through redaction authority, through bureaucratic discretion, through the 200 lawyers whose names we do not know, making decisions we cannot review, applying standards that violate the law they are supposed to enforce. Julian Assange spent 11 years detained for making one set of crimes visible. The redaction officers who are concealing another set of crimes will spend 0 days facing legal consequence. That asymmetry is not an accident. It is the structure, and what I observe as these files continue to be released in fragments over weeks, with promises of more to come, with each batch raising more questions than it answers, is that the permission structure is not being dismantled. It is being documented. Every redacted page is evidence. Every inconsistency is admission. Every newly discovered document is proof that concealment was active, not passive. The question now is not whether the system protected Epstein's network. The question is whether that protection will outlast the individuals it was built to shield, because what the redaction architecture reveals, what becomes visible in the pattern of what is shown versus what is hidden, is that some forms of criminality are considered too dangerous to expose. Not because exposure would harm victims, but because exposure would reveal how many institutional roles, how many lawyers, prosecutors, agents, administrators, officials participated not in the crimes themselves, but in ensuring those crimes remained invisible. That is the protection I am documenting, not protection of individuals, protection of the structure that enables individuals to operate with impunity as long as they remain valuable to the system that depends on their silence. And silence in this architecture is the most protected asset of all. End outrageous asylum, what despor outrageous asylum,